Welcome back, ladies and gentlemen, folks and blokes. Welcome back to this channel. This is a public notice to let everybody know that this channel is back online. It's Friday the 5th of January today, and I am making a tentative promise. Very tentative. I'm going to put out a video or a couple of videos every Friday. Friday is now my day where I come and sit at the desk and I update on what's going on, and this channel is now open. It's a public space. It's free for all to engage. I want to hear from you. I want you to comment. I want you to send stories to me. Tell me what you think is going on. Let's have a conversation about what's going on in Cambridge. The original concept of this channel, as you will see from the caption on the YouTube channel, is news and views from around Cambridge. It doesn't have to be specific to one thing, although there is a lot going on. You pick your moments, don't you, Neil? You pick your moments, don't you, Neil? I'm just in the middle of recording. What you up? What's up? No, it's all right. Well, hang on a minute. What do you think about saying a word directly to the very first video for Cambridge Cracker? Go on. It can hear you. Neil. Well, this is an open forum. This is the first video of hopefully a weekly intercourse about news and views from around Cambridge. What's going on in your world?
Okay. Well, in my world, I'm trying to support as much as I can keeping open the Mill Road Bridge, because quite frankly, the very concept of closing what is a major conduit of trade in the rest of Cambridge is ludicrous. So, as far as I'm concerned, all these ridiculous quotes that are being put around 72% being in favour of closing the bridge are out of the, and they're totally ridiculous. There we go.
There we go. Thank you, Neil. Well, that's perfect, because that leads me on to what I was going to talk about in this very video. But before I do, I suppose that's what you just said into, was it Talk TV you were talking to?
Yeah.
Jamie Tucker?
I did. I can play you a bit of what I did.
Well, you can send it to the email and then I could have it on the video later on.
I'll email it to you. I'll email it to you. That's a good idea.
Yeah.
Rather than phone call.
Alright.
If you want to do it, it's going out on Monday.
Monday. Perfect. That was lovely. Good timing, Neil. Thanks for calling. Call me anytime. And like I said, weekly updates from Cambridge Cracker every Friday.
If you need any input, give me a shout.
Well, you'll always be welcome. Thank you.
I'll forward that start recording to you.
Alrighty. Have a good weekend.
Yeah, hopefully the weather's good.
Alright. Take care. Well, there, what do you think about that, folks? Our very first contributor to the channel, Neil Mackay, the one and only Neil Mackay, the stalwart of anti-congestion charge campaign, the fifth generation Mackay, I think he's fourth generation Mackay of Mackays. In fact, I have the book up here. There's his old daddy. Anyway, we can go into all of this stuff as time goes by, I'm sure. It's, everything is a process. We do one thing at a time. And, yes, Neil brings me neatly onto the first topic, which I need to update you all on, is the Mill Road Bridge judicial review ongoing legal process. So, the thing to look forward to next is the 1st of February. We're having an interim hearing, a second interim hearing, which is like a summary hearing to decide whether there will be a hearing. It's called summary judgment. Let me read you this document. I am allowed to share this with you because this is in the public domain now. So I have made sure that this is free. This is fair game. Hang on a minute. I'm just got to find it. How is that empty then? Where does it go when you download something? Surely it goes into downloads. There it is. Just bear with me a minute. Here it is. Open. Alright. This is a order we got. We received this, or I should say our legal team received this from the courts on the 1st of December. This is an order by Dan Kalinsky, KC, sitting as Deputy High Court Judge. So he's read over the strikeout application which the council put in. Let's move this over here a little bit. The council, in their defence, applied for a strikeout, which is to tell the judge, this case has no merit, it has no grounds, it has no chance of winning, so save everybody time by throwing it out. So in order for that to be determined, there has to be a hearing to decide whether or not strikeout is going to happen or not. So we received this on the 1st of December. The defendant's application to strike out the claim, as amended, and for summary judgment should be listed for hearing with a time estimate of 2.5 hours and provision for judicial reading time of 3 hours. That means the judge has to read it in advance to become familiar with the facts of the case on the first available date on or after the 15th of January. That's actually my birthday, so we look forward to that. The defendant shall prepare and file a hearing bundle containing the material which is relevant to the applications and excluding matters relating to applications which have already been determined. This should be lodged with the court no later than 14 days before the hearing. The defendant shall serve any skeleton argument 7 days before the hearing. It is not required to serve a skeleton argument if it takes the view that its submissions have been adequately set out in the applications. These orders can be quite wordy, so just bear with me. The meaning will become apparent. The claimant shall serve any skeleton argument 3 days before hearing. She is not required to serve a skeleton argument if she takes the view that her submissions have been adequately set out in the response to the applications. The defendant shall lodge with the court an agreed bundle of the essential authorities relevant to the applications no later than 2 days before the hearing. This is just technical stuff. So that's just to say, get your paperwork in by this date, and then we'll look it over. Reasons. There is no permission stage applicable to this statutory challenge. To be honest with you, I don't know what that means. The defendant is making an application for summary judgment in effect to ask the court to determine the extent, if at all, that the claim is arguable. There are risks in taking that course, this judge says. If the application fails, even in part, there is the danger that additional costs would be incurred and more time spent as compared to the matter proceeding to a substantive hearing directly. The application dated the 14th of August 2023 sensibly anticipated that an oral hearing would be necessary to decide on the summary judgment application. So there's going to have to be a hearing, and an oral hearing, which is where people come into the court and speak. The matter came before the court on the 8th of November 2023, along with other applications relating to costs and interim relief. As explained in the judgment of Tim Smith, sitting as a Deputy High Court Judge, there was insufficient court time on that occasion to deal with summary judgment matter, and it would have been premature to do so given the application by the claimant to amend her claim. Mr. Smith directed, at paragraph 5 of the order, dated on the 8th of November, that the judge should consider whether the defendant's applications could be dealt with on the papers or required a hearing. It seems to me that, said Dan Kalinsky, it seems to me, consistent with the approach originally indicated in the application notice by the defendant, which provided for it to be determined at a hearing, this matter is of sufficient legal and factual complexity that the application for summary judgment requires an oral hearing to be fairly determined. I therefore give directions to that effect. And then there's this interesting little paragraph at the bottom. The defendant may wish to reflect on whether in these circumstances, it wishes to pursue the application rather than proceeding directly to a substantive hearing. In the event that the defendant changes its position, the parties can agree directions as to how the matter should proceed directly to a substantive hearing instead. Okay, so it's a bit wordy. Let's just go a couple of points just so that we're all clear on what we're looking at here. We're going to a hearing on the 1st of February. That has already been decided. Subsequent to this, we received an email on the 18th of December saying that the hearing is confirmed for the 1st of Feb. So that is in just under a month from now. If we look at the calendar, that is it's a Thursday. So Friday, 1, 2, 3 Fridays and 6 days. So we're looking at a roughly 4-week period now for the next hearing, and that is going to be purely to decide whether or not the summary judgment, aka strikeout application, is applicable, if you see what I mean. The defendant, that's the counsel, has applied for a summary judgment which requires its own hearing. In caption paragraph 9 of this order, Dan Zielinski, is it Zielinski? No. Kolinsky has suggested to the defendant that they may wish to reflect on whether in these circumstances it wishes to pursue the application rather than proceed directly to a substantive hearing. See, so our court case or our claim is going to have a hearing at the end where it's going to be decided whether to quash the TRO based on the grounds that we've put forward. But in the meantime, the council has applied to have the whole thing strucken out anyway. So we're going to have a hearing to see whether or not there should be a hearing. And all of that obviously just takes more, makes it last longer, takes more time, takes more money. Just make sure I'm still recording here. And the judge who's read over the summary judgment has said they may wish to reflect whether or not you should just go for the final hearing, because if you lose this summary hearing, it's going to incur more costs and take more time. Now, when we received that, I obviously don't know an awful lot about these circumstances. The first time, it takes me a little bit of time to understand what it is, but the people in the know, as in our barrister and solicitor and other members of our team, said that they've never seen a judge give such a sort of a piece of advice like Section 9 here. The barrister referred to it as steering. The judge has effectively attempted to steer the counsel away from summary judgment application and just to go directly for the hearing, which members of our team suggested that it was potentially to say you might not win this, so maybe don't go for it. But the council has stuck to their guns, they're going for it. So, ladies and gents, that's what we have to look forward to next with regard to the Mill Road Bridge thing. 4 weeks from today, in fact 4 weeks minus 1 day, we go to London again, to the High Court, just the same way that we did before. The High Court, or the Royal Courts of Justice on the Strand, as you saw in my previous video back in October, was it? Anyway, I'm going on for too long. I hope to keep these updates brief and short so that people can absorb them and not lose, the sight of what I'm doing or what we're talking about. And so let's round it up there for now. That's the first of this new Crackers output. The 1st of February, the High Court decision, summary judgment, the hearing to be a hearing, to hear or not to hear, in fact. Thank you, and I'll have to have a little round off for these things. Thanks for watching, if you have watched all of this way, and if you like what you hear or see, then give it a thumbs up, because that helps it to go up the algorithm so more people can see it. If you want to make sure that you don't miss future installments, subscribe to the video or subscribe to the channel, and it will appear in your feed as and when I put them up. You won't even need to be looking for them. This is William Burnell reporting for Cambridge Cracker. Let's call this channel Cambridge Cracker 24 because of 2024. We're in a new year, Cambridge Cracker 2024. So these videos will be, the format of the titles will be C.24.1 or C.24.2, so that all the videos will be catalogued with a little reference number, which I like that sort of thing. And and we'll be able to refer back to them as and when, because there's going to be regular output from now on. I've got loads of material that I want to talk about. Don't know how this is going to go yet. I've got a whole wodge. This is all material collected from the last year, talking about the congestion charge and things. We've got more stuff here. I haven't sorted through it yet, but this is all the kind of material which is going to be ending up in the next book. Speaking of which, the book is what I want to talk about in the next update. So let's round this one off here for now. That's Cambridge Cracker 24.21, and stay tuned in for the next installment in just a few moments.
Final warning. Primary power offline in 10 seconds.